Academy for Social Change presents the 15th Amendment. In the 5 years following the Civil War, the 13th, 14th, and 15th constitutional amendments were passed to extend civil rights and legal protections to those who had previously been enslaved. These laws are often called the Civil War Amendments or Reconstruction Amendments, as they were passed in the Reconstruction era. Although enslaved African Americans had been freed by the 13th Amendment in 1865 and granted equal protection under the law by the 14th Amendment in 1868, there was much debate on whether or not they should also receive the right to vote, a right that had previously only been granted to white men. About half of the seemingly tolerant northern states still denied this right to black people when Republican President Ulysses S. Grant was elected in 1868. Recognizing the importance of African American voters and ensuring the success of Republicans against conservative Southern politicians, the party drafted various proposals centering on extending suffrage and presented them to a divided Congress. Eventually, the most moderate version was accepted by a majority of the legislative branch in February 1869 and subsequently sent to the states for ratification. When some states resisted, Congress decided to require Southern states to ratify the 14th and 15th Amendments in order to return to the Union and regain representation in the legislature. On February 3, 1870, the 15th Amendment was officially ratified nearly 2 years after its predecessor as the third and final Reconstruction Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have power to enforce this article by appropriate legislation. Quite simply, the 15th Amendment means that African American men, including those who were previously enslaved, are allowed to vote in elections. The amendment does not extend to African American women, as no women were allowed to vote until the passage of the 19th Amendment 50 years later. However, the right to vote could no longer be denied on the basis of race, at least in theory. In a 1915 case, Gwynn v. United States, the Supreme Court ruled that a clause in Oklahoma's Voter Registration Act of 1910 was unconstitutional under the 15th Amendment because the law required literacy tests only for prospective voters whose grandfathers were not able to vote. It applied almost exclusively to African Americans. Black people could also be refused a literacy test for any reason, effectively barring them from voting. This law was one of many attempts by states seeking to indirectly limit black people's ability to vote, in direct contradiction of the 15th Amendment. While not completely outlawing literacy tests or other voter suppression tactics, the case made it clear that racially discriminatory electoral laws would be subject to close inspection from then on. Surprisingly, many notable suffragettes, such as Elizabeth Cady Stanton and Susan B. Anthony, opposed the 15th Amendment, believing that African American men should not get the right to vote before white women. Most of the Democratic Party, particularly Southerners, opposed extending suffrage to anyone beyond white men. Thus, there were both complaints that the amendment didn't go far enough and that it went too far. After the amendment's passage, voting rights were hindered by rampant voter suppression, which started in the late 1870s and became very popular among state and local legislators, particularly those in the South. Poll taxes and literacy tests were implemented that intentionally discriminated against black people, most of whom were poor and lacked access to basic education after generations of enslavement. As the years passed, even wealthy African Americans were told they were not allowed to pay the tax, and those who were college educated were often denied the literacy test or told they failed. Until the poll tax was eliminated by the 24th Amendment in 1964 and the Voting Rights Act of 1965 banned the use of literacy tests, the 15th Amendment was essentially null and void in some places. Even today, the prevalence of modern voter suppression tactics disproportionately impact African Americans and prevent many from casting their ballots. African Americans are more likely than their white counterparts to live in gerrymandered legislative districts that take away the power of their vote. They're more likely to lack a government-issued form of identification, meaning that in many states they can be turned away at the polls under the guise of preventing voter fraud. They're more likely to have their names wrongfully removed from voter rolls, especially in regions with histories of racial discrimination. Although no state or person is allowed to turn a voter away at the polls solely because of their race or the color of their skin, there are a variety of more subtle discriminatory practices at play that ultimately have the same effect. Our democracy is most representative when every person has the ability to cast their ballot and make their voice heard in the political process. The 15th Amendment was a landmark civil rights achievement that laid the foundation for African Americans to not only participate politically, but become leaders in government at the local, state, and federal levels. It paved the way for the 19th Amendment, which granted women the right to vote, and eventually emboldened the civil rights leaders of the 1960s to advocate for justice after promises of equality remained unfulfilled. Despite the progress that has been made, however, racially marginalized populations continue to have their voting rights threatened by legislation that erects targeted barriers to voting at every level. Just as the Voting Rights Act of 1965 combated earlier forms of voter suppression, a new law may be needed to ensure that the right to vote shall truly not be denied or abridged on account of race. Now it's your time to think further. How did literacy tests and poll tax subvert the original intention of the 15th Amendment?